In a big decision, a 5-judge constitution bench has upheld the constitutional validity of the Constitution 103rd Amendment Act 2019, which provides for 10% reservation in appointments to the post under the state and in admissions to educational institutions to economically weaker sections or EWS of citizens. While Justices Dinesh Maheshwari, Bela M. Trivedi and J.B. Pardiwala wrote separate but concurrent opinions forming majority, Justice S. Ravindra Bhat wrote the minority opinion for himself and Chief Justice U. Lalit. Three issues that the court was called upon to decide were whether the 103rd constitutional amendment can be said to breach the basic structure of the Constitution, 1. By permitting the state to make special provisions including reservation based on economic criteria, 2. By permitting the state to make special provisions in relation to the admission to private unaided institutions, and 3. By excluding the SEBCs, OBCs, SCs and STs from the scope of EWS reservation. The majority answered all three issues in negative and upheld the constitutional validity of 103rd Constitutional Amendment after observing that reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India. Rather, it is an affirmative action on the part of the Parliament for the benefit and for the advancement of the economically weaker sections of citizens. There was, however, a consensus on the aspect that it was time to move towards an egalitarian, casteless and classless society, and to achieve that, time limit should be prescribed for the special provisions in respect of reservations and representations provided in Article 15 and 16 of the Constitution. CJI Lalit and Justice Bhat dissented on the third issue and held that the exclusion of SEBCs, OBCs, SCs, STs from the scope of EWS reservation was unconstitutional. They explained that the exclusionary clause operates in an utterly arbitrary manner as, first, it others those subjected to socially questionable and outlawed practices, though they are amongst the poorest sections of society. Second, for the purpose of the new reservations, the exclusion operates against the socially disadvantaged classes and castes absolutely by confining them within their allocated reservation quotas, that is 15% for SCs, 7.5% for STs, etc. And third, it denies the chance of mobility from the reserved quota based on past discrimination to the reservation benefit based on economic deprivation. Now, the problem here is that on one hand, the state is using a neutral identifier for the 10% quota that is entirely based on economic status. Yet, in the same breath, the state is saying that the members of certain communities who may be equally or desperately poor would not be able to access this new benefit since they belong to certain reserved communities. Hence, it was observed that the othering of socially and educationally disadvantaged classes, including SCs, STs, OBCs, by excluding them from this new reservation on the ground that they enjoy pre-existing benefits, is to heap fresh injustice based on past disability.